The chair recognizes the representative from Brooksville, Representative Chapman.
Thank you, Madam Speaker. Friends and colleagues of the House, a few weeks ago I rose in this chamber to make a comment about the separation of the branches of government. And because the House order before us at this moment is somewhat unusual, I thought I'd take a moment or two to give a little bit of explanation procedurally of how this really works. So I'm going to start by reading one short paragraph in the Constitution of Maine, Article 6, Judicial Power, Section 3, to give opinion when required by governor or other branch of the legislature. The justices of the Supreme Judicial Court shall be obliged to give their opinion upon important questions of law and upon solemn occasions when required by the governor, Senate, or House of Representatives, unquote. This is an example where there is a slight connection between the branches of government, and clearly the purpose of this particular connection is to allow the other branches of government to get some advice from the justices of the Supreme Judicial Court. Unlike a court decision, which has the force of law and sets precedents, advice from the justices does neither. But let me explain at least my familiarity with what questions have been brought to the justices of the Supreme Judicial Court during my tenure here in the legislature, and what the outcome of that has been. Because, as it might be easily imagined, the justices of the Supreme Judicial Court are not eager to enter into the business of the legislature or the business of the executive branch. And so they review requests of questions that come to them in a very narrow fashion. Just to give an idea of what the recent questions have been, in the 125th legislature, this body, the House of Representatives, sent a question to the justices relative to the nature of business relationships vis-a-vis the treasurer of the state, and the justices declined to answer the question. Next, the chief executive asked a question of the justices dealing with the relationship of the Attorney General to the executive branch relative to hiring of legal help. And again, the justices declined to answer that question. In the 127th legislature, the chief executive asked another question of the chief of the justices of the Supreme Judicial Court relative to what the nature was of adjournments by the legislature relative to the timing of his veto authority. And in that case, the justices did offer an opinion. You might recall that there were about 6 laws that, whether or not they were enacted and in force or not, was in question. And so this rose to a level of both immediacy and importance that the justices took on that question and provided their advice. And then finally, in the 128th legislature, we have an instance in which the other body, at the other end of the hall, asked a question of the justices relative to citizen-enacted legislation around ranked choice voting. And again, due to the immediacy and importance of it, the justices did provide their advice. Now, finally, let me turn to why I believe the question that is being propounded in this House order is appropriate for us to ask, and why I believe the justices would take it up. And that is to say, the question really has to do with the application of a United States Supreme Court ruling to what we in the state legislature are authorized to do. Do we as a legislature have the authority to regulate gaming on tribal land? Can we prohibit it? Can we allow it? Can we regulate it? This is the basic question that we need to know prior to our enacting laws that might seek to prohibit it or allow it or regulate it. And for that reason, it's both timely and important, because this has to do with the application of the law of the land, case law from the United States Supreme Court, on what we as a legislature can do. Thank you, Madam Speaker.
The chair recognizes the representative from Auburn, Representative Sheets. The chair is in error.